Good afternoon again, Senator McGuire. Welcome. Please proceed when you're comfortable.
Well, good afternoon, Mr. Chair and committee members. First of all, I just want to say thank you to the chair for your evaluation of this bill and the opportunity to be able to present to your committee today. It's good to see everyone. Hope all of you had a good weekend. Senate Bill 1174 stems from a growing and significant concern over the excessive prescription of psychotropic medication to foster youth in California. It follows a series of hearings by the California State Senate on Health and Human Services committees regarding the oversight and monitoring of psych medication in mental health services for youth in foster care. Even with the growing attention to this situation, the problem is now even more severe than ever. In California's 63,000 foster youth are the ones who are suffering the consequences of our state's inaction and lack of oversight over the past 15 years. I would like to be able to start out today with some statistics. Even with the current safeguards in place, the JV 220 process, whereby judges decide what medications and at what dosage are provided to foster youth, over the past 15 years, the rate of foster youth being prescribed psychotropic medication has increased 1,400%. 1,400%. Nearly 1 in 4 California foster teens are prescribed psychotropic medication. Of those, nearly 60% were prescribed an antipsychotic. This is the most powerful drug class that is susceptible to damaging side effects. 36% are prescribed multiple medications. To make matters worse, many of these antipsychotics are off-label, estimated to be at about 75% of all prescriptions. And off-label means they have not been approved by the FDA for prescribed use. As reported by the San Jose Mercury News, the Food and Drug Administration authorizes antipsychotics for children only in cases of severe mental illness. But evidence suggests medical professionals often prescribe them to California foster children for behavioral problems. In addition, California spends more on psych meds for foster children than any other kind of medication. In the last decade, California spent more than $226 million on psych meds for foster kids, an astounding 72% of the entire total spending. Additionally, there are substantial long-term costs of treating side effects associated with these medications. Psych drugs are potent medications that have well-known and documented side effects that include serious, lifelong, and irreversible impacts if they aren't prescribed appropriately. These could include rapid onset obesity, diabetes, and the impacts can be so profound that foster youth describe dozing through school and much of their young lives. Teens in foster care are 3.5 times more likely to be prescribed psych medication than their peers who are not in foster care. And while the Child and Family Services Improvement and Innovation Act of 2011 requires each state in our union to oversee and monitor the use of psychotropic medications, California currently has no requirements to identify those who are overprescribing medication to foster youth. We have no system for evaluating the medical soundness of high rates of prescribing, and no way, by the way, to measure the efficacy of these practices. This is absolutely unacceptable, given that it is the state's responsibility as the guardian of these kids to monitor the administration of these drugs and to ensure the health and well-being of foster youth. In 2014, Senator Ted Lieu, as chairperson of the B&P committee, sent a letter to the medical board pointing to findings that doctors are prescribing drugs that have not been approved for children and that they are sometimes prescribing without reviewing the use medical records or drug history. He called on the medical board to conduct an investigation into these medical professionals and come up with recommendations to minimize these dangerous practices. So where are we at now, 2 years later? In response to legislative pressure, and I'm greatly appreciative of this, the Medical Board and the Department of Healthcare Services adopted a one-year trial data use agreement that allows for the sharing of prescriber data in order to identify the outlying prescribers. And again, I want to thank them for that. Such data sharing practices should not be a one-time basis, but rather an ongoing process for improving the quality for prescribing to our children. SB 1174 establishes a formal, ongoing process for the California Medical Board to responsibly review and confidentially investigate, let me say it again, confidentially investigate psychotropic medication prescription patterns outside the standard of care. With this data sharing agreement with DHCS, the Medical Board will have regular, reliable information to work from, instead of depending on current individual complaint process, which we have now. And by the way, this complaint process about potential overprescribing has turned up 0 cases related to foster youth. So right now, the complaint process that we have has not advanced one single complaint from one single foster youth here in the state of California. SB 1174 will alleviate the alarming data disparity between private and foster care system complaint rates. Although SB 1174 simply engages the ordinary regulatory role of California, I would like to address some concerns that we have heard. Number one, it is important to note that this bill applies to only a very small percentage of prescribers. The vast majority of medical professionals prescribing medication are doing so appropriately. And this is true. They are doing so appropriately. This bill targets only that small number of outliers who are engaging in potential violations of law or excessive prescribing defined by the parameters set forth in nationally accepted measures and guidelines adopted by a multidisciplinary group of healthcare professionals. In fact, the current data use agreement only shares data on foster kids that have been on 3 or more psychotropic medications for 90 days. And I also want to clearly point out the privacy protections that this bill advances. Under California law, all medical board complaints and investigations are completely confidential until the point they are turned over to the Attorney General's office. Even information on misdemeanor convictions that did not result in accusation is protected under these privacy measures. So let's put this in perspective. In 2014-15 calendar year, the Medical Board received 8,267 complaints, of which only 1,381 cases were opened for investigation at the Medical Board. From there, only 471 cases were referred to the Office of the Attorney General for filing a formal accusation. And this formal accusation is essentially the charging document to take disciplinary action. And from that 471 that we're talking about, it actually was narrowed to 365 that were actually investigated by the Attorney General. And then by the end of the process, in that year, only 47 medical professionals were disciplined for inappropriate prescribing. That's it. SB 1174 is necessary because it looks across patients for an individual prescriber and asks if there are patterns of prescribing that are excessive outside the realm of appropriate standards. It protects doctors and medical professionals who work with high-needs populations through ensuring quality experts at the Medical Board analyze individual health factors and medical records just like they would do for any other case. Finally, it is simple, without data, that the Medical Board simply can't do their job. And their job is to have oversight authority. SB 1174 will enable California to implement what is already standard oversight practice in the states of Washington, Illinois, Ohio, and Maine. These state initiatives have shown a 25% decrease in dangerous prescribing practices and have improved the overall prescription frequency for all medically acceptable reasons. And I want to finish with this, Mr. Chair. I've had the pleasure of meeting with stakeholders over the last year on this issue. In fact, last year I held a bill because it wasn't fully cooked. And I did that because personally I needed to do additional research with our coalition. And that is why we advanced this bill here today, to be able to extend the data sharing use agreement between the two departments. And I look forward to continuing to work together to improve the bill in the next couple of months. And I do want to say thank you to good folks from the California Medical Association and the Psychiatrists Association for their engagement. And I really do appreciate all of their work that has gone into this bill over these past many months. Senate Bill 1174 is supported by the National Center for Youth Law, California Youth Connection, the California Pharmacists Association, Consumer Watchdog, among many others. Mr. Chair, I have with me today the fantastic Executive Director of the California Medical Board, Kimberly Kirchmeier, who I think is not a stranger to this committee. And she's just going to be given the facts today. She'll describe the privacy protections and the current investigation process. And to be able to provide testimony, we have Bill Grimm from the National Center for Youth Law, Tisha Ortiz, a former foster youth, and Vanessa Hernandez from the California Youth Connection. And I would respectfully ask for an aye vote, but if it's all right with you, just to be able to describe the process with the Executive Director.
Very good. Thank you. That's wonderful. Welcome.
Well, good afternoon.
Good afternoon.
Senator Hill and members. I just want to go over and first let you know that the medical board has not taken a position on this bill yet. This really is just technical assistance that we've provided working with the author's office. And one thing I want to really point out is just to reiterate what Senator McGuire said, and that is that this review process that the medical board will undergo and that we are undergoing right now, it is confidential. So that information, we get the complaint, we get the data, we review it, and then that investigation, that whole process is confidential until the point of that accusation being filed. So that's one thing I just want to make sure that is clarified and that everybody understands. Then just to go into the process a little bit, the reason we think it's important for the medical board to look at this, and we know that the Department of Healthcare Services looks at the information as they receive it, is because they're really looking for fraudulent activity and billing. They're looking a little bit differently than the medical board. What we're looking at is that we're looking at the quality of care that that physician is providing. And then the other thing that we think is important is that the medical board is the only entity that can actually take disciplinary action against a physician. The Department of Healthcare Services can remove that person from being a Medi-Cal provider, but they can't actually remove the individual from practicing. They could just stop being a provider and move on down the street to another entity providing service. So just to give you a little bit about the process where we've come from with this issue, we did receive the letter from Senator Hill, and then once that happened, we actually held several meetings with the Department of Healthcare Services and Department of Social Services trying to identify physicians that were inappropriately prescribing. So basically, after we had the meetings, we set up some criteria, working with them to identify it. And Senator McGuire went over a little bit, but just to be very specific, what we were really looking for in this data use agreement and what the information that they provided was physicians who had prescribed 3 or more psychotropic medications for 90 days or more. And then for each child, we requested a list of the medications prescribed, when that was started and stop date for each medication, the prescriber's name and contact information, and then the child's birth. And then we asked for any other information that they thought may be helpful to the board to make a decision. Upon receipt of that information, the medical board actually sent it to a child psychiatrist, an expert, that we wanted to look at that data because there's no medical records or anything yet that have been provided to identify individuals who they thought may be inappropriately prescribing, so then we can actually start our formal investigation process. So we sent the information out to a child psychiatrist. They came back and told us that additional information was going to be needed in order to identify those that may be inappropriately prescribing. So right now we have talked to the Department of Healthcare Services and Department of Social Services, and we asked for new information, including the diagnosis associated with the medication, the dosage of medication prescribed, the schedule of that dosage, and then the weight of the child or adolescent, because that all weighs in on whether it was appropriately prescribed. So we're currently working with those two entities to obtain that additional information. And again, I just want to reiterate, 2 things that are important is that all those complaints and that whole investigation process, it is confidential until the point an accusation is filed. And again, just to reiterate that is the formal charging document that begins a disciplinary action, that disciplinary process. And then also that once a physician is identified to be potentially inappropriately prescribing to this foster care child, that the board's normal complaint process will be taken. It won't be any different than any other complaint that we receive. And that means that we'll be going through the process of obtaining medical records, conducting a physician interview, and then going forward with an expert review to then determine whether there is actually a violation of the Medical Practice Act. So with that, I'll pass it on.
Very good. Thank you for that, that information. I think that's very helpful for the committee to really understand where we are with the issue. So thank you. Yes, other witnesses in support?
Yeah. Hello, my name is Tisha Ortiz, and I am 23 years old and a current student at Cal State East Bay. I'm a former foster youth, and I first entered the foster care system at age 4. I went in and out of the system from ages 8 to 12 and re-entered at 12 and stayed until I emancipated at 18. I went through many traumatic experiences in and out of the foster care system. I was physically, emotionally, psychologically, sexually, and verbally abused. I'm 23 years old, and I have never had a doctor that actually helped me with these issues. I needed help to get through the traumatic experiences that I had been through. Instead, I ended up in a group home at age 14 where the doctors tried to treat me with various powerful drugs. At one point, I was on 4 different classes of medications: an anti-anxiety, an antipsychotic, an antidepressant, and a mood stabilizer. This consisted of me taking 12 pills a day, 6 in the morning and 6 at night. These powerful and sedating psychotropic medications caused serious side effects like weight gain. I had a swollen tongue, tics all over my body, and I couldn't stay awake in class. I was normally an A and B student, and all of a sudden I'm failing. I had tunnel vision, and I felt like a zombie. I also developed an irregular heartbeat because of these medications. When I would try to talk to the doctor in the group home, the doctor wouldn't listen to my concerns and told me that I didn't know what I was talking about. And the 5-minute sessions that I did have with the doctor, they were all about upping or adding on more medication and not what was really going on with my mental health. What I actually needed was therapeutic behavioral services to help deal with self-injurious behavior and low self-esteem, and trauma-focused therapy to get through the traumatic experiences I had and was still continuing to go through, like my mother passing away, as well as the sexual abuses I went through from my neighbor, and the police officer who investigated the sexual abuse also sexually abused me. This was not even on the surface of the abuse that I went through. Doctors wouldn't even listen to me about what was going on with me, and that I was having constant flashbacks from my trauma. Instead of listening to me and my needs around my mental health, the doctor would have a 30-minute session with a group home who would give the doctor their biased opinion on how I should be medicated. Eventually, I moved to another group home that didn't have a doctor contracted by the group home, but instead, I had a doctor that was from County Behavioral Health. The second the doctor noticed the alarming amount of medication I was on, he slowly took me off these medications and listened to my concerns about not wanting to be on medication and that I needed help to cope with the trauma that I went through. Finally, 3 months before aging out, I was set up with a trauma-focused therapist. Those services were given to me too late, when I was already going to turn 18 and exit out of the system. I needed that support earlier and for more time. Doctors who work with foster youth need to be educated on trauma and the differences between behaviors and mental illnesses. I was exhibiting behaviors that doctors wanted to medicate me for, instead of actually helping me deal with the trauma and learn how to cope without self-harm. SB 1174 will help identify doctors who are too quick to prescribe medications and who are over-reliant on them. SB 1174 will provide an opportunity to ensure these prescribers understand the standard of care and are distinguishing between behavioral issues and mental illnesses and trauma. SB 1174 will improve the health, safety, and well-being of foster youth like me. Please approve Senate Bill 1174 so we can stop drugging our kids.
Thank you very much for being here today and sharing that testimony. Thank you. Yes, other witnesses in support?
Mr. Chairman, members of the committee, my name is Bill Grimm. I'm senior attorney with the National Center for Youth Law. I'm also a member of the state's expert panel on psychotropic medication and children in foster care. and that expert panel has been responsible for approval of the guidelines for psychotropic medication amongst our foster youth that were recently adopted and now are published online, both at the Drug Utilization Review Board, and I think also the Medical Board of California has them on their site as well. Last year, we worked with this legislature to enact 3 bills, Senate Bill 238, 319, and 484, that addressed one aspect of the psychotropic medication issue. Primarily, that addressed the oversight of children in foster care who were receiving those medications. So we sought to buttress the authority of public health nurses to oversee children on their caseload that were receiving psychotropic medications. 238 called for training of all those involved in the oversight, caseworkers, foster parents, other caregivers, dependency court judges, and attorneys as well. And 484 focused upon the overuse of medications explicitly in the group home context. The bill before you, SB 1174, approaches the problem from another angle and another aspect of the problem, and that is it focuses on the prescribers, as Senator McGuire has told you, on really the outliers, so those physicians who, for one reason or another, are prescribing 3 or more medications, psychotropic medications that we know from the literature. There is no scientific basis for that, and as you prescribe more psychotropics for children, the literature clearly shows both the nature and the severity of the side effects expands exponentially. SB 1174, under the current law, rather, the medical board investigates when there is a complaint. And as Senator McGuire pointed out of the 8,000 some complaints, not one originated from children in foster care. And I think that's understandable because children in foster care don't know anything about the medical board. They don't know that there's a complaint process. And so SB 1174 addresses this problem by gathering data from the existing databases at the Department of Healthcare Services and CDSS, and then passing that information on to the medical board, the people with the expertise to evaluate whether there is clearly excessive prescribing. There are 2 practices in this bill that this bill seeks to address, and that is, first of all, whether there's a good faith examination of the child before the prescribing occurs, and from our many testimony last year, we know this is a problem, and secondly, clearly excessive prescribing. So you can see by using the standard of clearly excessive prescribing, this does not sweep very broadly, but focuses on the outliers, those prescribers who are really far outside the nationally accepted standards set by HEDIS and by our own California guidelines. In closing, I want to address a couple of the concerns that have been raised, I believe, by the medical associations. One of these has to do with the privacy concerns, that somehow this bill is going to interrupt or interfere with the privacy rights of patients and doctors. That's just not the case. I mean, going back to 1920, when the medical board was given the authority to issue investigative subpoenas, and with the decision of the Court of Appeals in the Woods case, it's clear that, you don't get access to patient records until you have proven good cause. So the concerns about privacy really are, as far as we're concerned, a non-starter here. Existing statutes and existing case law, including the Woods case, make it clear that you have to show good cause to get access to patient records. And the other aspects of those cases are that when you are given access to patient records to determine further whether the suspicion of overprescribing is actually overprescribing, you're only granted access to that portion of the patient records that are necessary to make that determination. So I suggest to you that the concerns about privacy are already addressed by our existing case law and our existing statutes. In closing, I want to give you an example, a conversation I had with a mother of a child who's in the system. This is a 14-year-old boy, Joseph, who has been on multiple medications, including multiple antipsychotics. He went from 126 pounds 13 months ago to over 200 pounds while on those medications. He suffers from tremors and tics. And as some of you may know, one of the side effects or adverse effects of risperidone is the young boys may grow breast tissue, and Joseph is suffering from that adverse side effect as well. It is for those children, the Josephs of this world, for which SB 1174 is necessary, so we can identify those prescribing practices that are so far outside the standard of care that we have to take some remedial action to save those Josephs of our world. Thank you.
Very good. Thank you very much for the testimony and for that example. Appreciate it. Those in support, and if you could be as brief as possible, it would be great. Thank you. Oh, I'm sorry. Yes,
Vanessa.
I'll keep my comments
because it went that way,
brief.
so I
Yeah.
apologize.
No problem. I'm with California Youth Connection, a youth-led organization of current and former foster youth. Our members strongly agree that over-medication is a problem in California. In most cases, a child or youth have a loving parent to be that guardian for them, to protect them and oversee any prescriptions given to them. However, that's not the case, and nor is it the reality for foster youth, especially the youths placed in congregate care or group homes. We strongly support SB 1174, which will create that oversight and that accountability by allowing the Medical Board of California to collect and analyze that data to fill the systematic gap. For these reasons, we ask for your aye vote.
Very good. Thank you very much. Others in support, please. Thank you.
Linda Way with Western Center on Law and Poverty. We represented the original plaintiffs in KDA versus the state, which sought to ensure that foster youth have access to appropriate mental health services in a home and community setting, and we support this bill.
Thank you. Next witness in
I'm
support.
Shaniqua Arrington. I'm a former foster youth, and as someone who's taken multiple medications and had the side effects up until I still have some of them, I support this bill.
Thank you for being here today and sharing that.
Good afternoon, Mr. Chairman, members. Ed Howard with the Children's Advocacy Institute at the University of San Diego School of Law. I just wanted to underscore one point that I hadn't heard yet, that is an additional benefit to this bill, given how narrowly drafted the enforcement provision is. Given how narrowly drafted it is, if you have a physician who, in repeated acts, has engaged in clearly excessive prescribing, quote, without a good faith prior examination of an abused and neglected child, it's not just going to be a problem with that particular child. If you have a physician that falls into those narrow categories, there are going to be other issues involved with that physician. This is a canary in a coal mine for all of California patients, and we urge your aye vote. Thank you.
Great. Thank you, Mr. Howard. Good
Hi,
afternoon.
my name is Catherine Snyder. I'm an attorney with the Advocacy Fund, and I'm also a former foster youth. And I want to say that I strongly support this bill. I was very lucky and wasn't medicated while I was in foster care, but my brother, as well as many of my friends, were. And I still see the impact of that to this day. And so I implore all of you to take this one step for us to stop prescribing medication in response to trauma. Thank you.
Very good. Thank you very much. Others in support? See no one. Is there anyone here in opposition, please? Could I ask? Thank you. Good afternoon, gentlemen.
Good afternoon, Chair and members. Stuart Thompson on behalf of the California Medical Association. I just first want to start by thanking the author, the sponsor, but especially the witnesses who just provided their testimony. Obviously, based on that testimony, we have real problems within the foster youth system, real structural problems that take a multifaceted approach to correct. We are opposed unless amended to this bill. We want to first just say that we plan to continue working with the author and sponsor, and we hope to eventually support this bill. Our main opposition comes from the fact that the CMA doesn't actually think this improves health benefit outcomes for foster youth. This bill allows data sharing between DHCS and the medical board. They can already currently do that. They don't need legislation to. And so just first off, we don't have any problem with the data sharing agreement between those two agencies. What we do have the problem with is this is going to be a retroactive look at prescribing practices, meaning a typical medical board investigation takes 1, 2, 3 years. So any corrective action that would be taken under this bill would be, quite frankly, years after a child would have received medication that they shouldn't have gotten. So for us, we are looking for some sort of educational outreach or an ad hoc committee that could provide the court that approves the JV 220 process with perhaps some medical expertise to push back on inappropriate prescribers. Just to give you an idea of of what a physician has to do currently in order to be authorized to provide this type of medication to foster youth. They first have to submit a JV 220 to a local court. That court, and there was a bill by Senator Mitchell last year, SB 238, that beefed up exactly what was supposed to be contained in that JV 220. It's basically a one-page form with a physician statement on the back end outlining a number of criteria. It's contained in our letter, but it's discussion of the symptoms, proposed treatment, the drugs that they propose to use to alleviate this treatment, and it's currently in a rulemaking to beef up this form. So for us, we think an appropriate idea for this bill might be to form an ad hoc committee of specialists, child psychiatrists that the court could at least rely upon in determining whether the JV 220 process, or excuse me, whether the application is actually an appropriate use for psychotropic medication. After a court approves that process, all foster youth are currently under Medi-Cal, so the physician would then send basically a claim to DHCS for approval of the treatment. So for each one of those, they're called Treatment Authorization Request Forms, TARs, it's kind of the acronym that we use. There's a pharmacist at DHCS who reviews each one of those for medical necessity. So not saying that obviously the system has major problems, but for each anti-psych prescription that is made for a foster youth, there is court approval and there is a pharmacist that ensures that it is medically necessary. So for us, again, we don't have a problem with the data sharing in concept, but we do think there should be some educational outreach to both the providers and to the courts that approve these applications so that kids aren't prescribed these medications in the first place. Regards to the data that will be shared, and correct me if I'm wrong, but I believe it's the child's age, weight, height, the diagnoses, the proposed drug to be used, the dosage of that drug, and the timeline over which that drug is to be provided. We do have some concern that given those data points, these are from medical records, and obviously there's some confidentiality and HIPAA concerns. Based on those data points, it will identify certain physicians who actually specialize in providing mental health treatment to those patients suffering from the most severe cases. Because if you look at those 7 data points, we really think that volume will be a major factor in determining whether to initiate investigation for a physician. And there's going to be some physicians out there who are working well within the standards of care, but have quite higher prescription numbers based on the patient population that they serve. I think the goal here, and I'm paraphrasing, I think the author and sponsor, is to provide the foster youth with non-pharmacological treatments, with therapeutic treatments that aren't based on drugs. And we share that same goal. For physicians working within the system, I think we must note that a lot of mental health therapy is not provided by physicians. It's provided by fantastic, qualified mental health professionals, but there's no reason that you need a physician to make a referral to get access to these treatments. Quite frankly, there's and I think everyone at this on this committee is aware of it, there's some access problems to mental health services within the Medi-Cal system. And you don't need a physician to say in a treatment plan that a certain child needs therapy. You would hope that the county or the healthcare service plan that manages that child's healthcare would be providing that already. And even if a physician did see a child and recommended that they meet with a therapist once a week, that physician has no ability to compel the responsible entity to provide that treatment. So again, we are opposed to less amended. We do hope that some educational outreach pieces are added to the bill, or maybe a committee that can better help the court to make better decisions on the JV 220 process. But we think, right, the bill in its current form provides a retroactive look at physician prescribing practices. And again, we have no problem with the data sharing agreement, but we don't think it actually provides better health outcomes for foster youth.
Thank you for the testimony. Others in opposition?
Thank you, Mr. Chair and members. Christopher Castrillo on behalf of the California Academy of Child and Adolescent Psychiatry. First, just want to echo the concerns and the concepts that my colleague, Mr. Thompson, just put out. Secondly, we've been working very closely with Senator McGuire and the sponsors dating back to last year on a lot of these issues. Just want to be very clear that we do have an opposed unless amended position, but with that being said, we're very confident that we can get to this place that Stu referenced as sort of an educational first approach, as opposed to taking an an enforcement first look. There's a wide variety of prescribing physicians in the Medi-Cal system. I obviously represent the California Academy of Child Adolescent Psychiatry. We think that there's some opportunity here for particularly child adolescent psychiatrists to provide some expert consultation, to take a look at prescribing practices, utilize a lot of the educational pieces that have been coming out in the last year. Stu referenced a few of the processes that you have to go through to prescribe a psychotropic medication of foster youth. The TAR process, that recently expanded a year and a half ago. He mentioned the JV 220 process that's currently being reviewed and looked at by Judicial Council and is set to be expanded by July 1, 2016. The sponsors, and they're up here earlier, talked about a lot of the great work that they did last year. We were in committee just this past week urging for more additional funding for public health nurses. There's a lot of moving parts to the foster care system right now, and some of it is ripe for providing outreach and saying, this is what's going on. This is a new landscape here. We want to make sure that you are taking a look and doing the best prescribing practices possible. We think we're well suited to do that. And I think that we are in agreement that there's a space within this bill where we can find that sweet spot to bring up the quality of care for these foster youth. So with that, I'm confident I'm moving forward, and thank you very much.
Thank you very much. Others in opposition? Seeing no one, bringing it back to the committee. Questions? Yes, Senator Wachowski.
So at the end of the day, doesn't this all come down to the juvenile court's order, right? I mean, at the end of the day, that child is not getting those psychotropic judges or meds unless a judge has signed an order, and that order continues to have all the force of the court. So I assume right now that the Mitchell bill is if the judge gets clearly excessively prescribing information before her, she can say, I want to have this JV-22 or this whole medical condition reviewed. So tell me how, when this becomes law, the medical board does their, they're looking at from a doctor's point of view, who's excessively prescribing these psychotropic drugs, right?
I'll go into an overview, and I'll let the medical board be able to go into the detail. So right now, that JV 220 process is a snapshot of time. So it is when that foster youth would be in front of that administrator and or the judge. They will prescribe based off of what those conditions are for that child. But that's the biggest issue that we have right now. It's a snapshot in time. And that is what we want to be able to utilize as a medical board here. So a couple things. One, some say that we don't need this bill because the data is already being shared. Well, it's being shared for 1 year. Number two, what we know is for as long as that child is in the system, prescriptions change. They may go up, they may go down. But that JV 220 process is a snapshot when that individual is in front of the judge. And we're open to be able to discuss any educational initiatives, but bottom line is we need to be able to see language of what that really looks like. And we've requested language in regards to the educational initiatives. But medical board, I don't know if there's anything else that you want to be able to.
Well, I guess the question is how does the judge, let's say the bill gets enacted and the medical board is looking at all the, subscription or prescriptions that these doctors have been prescribing, and they say, oh, it looks like Dr. X is overprescribing this and that Dr. Y is overprescribing this. How does that get back before the judge? Because nothing changes unless you have a judge's order. That judge is still ordering that kid under he's a ward or she's a ward of the state. How does that work?
You hit the microphone.
We would actually be looking at it from the physician's perspective as whether they violated the law and taking action against them. We share data back and forth between the agency, so we haven't really talked about this, but I'm assuming that if we found out that there was a problem with the overprescribing physician, that we could notify the Department of Healthcare Services so they could look into that JV process that happened. But again, it goes back to what Senator McGuire says, at that one snapshot, that might have been okay, but over time and over the course of this care and treatment of this individual, there might have been inappropriate prescribing, but at that one point, you might not have been able to see that.
Senator Whitehouse, I just to clarify, I think we are talking about two separate things. Stuart and I, we mentioned there's essentially two processes for the Medi-Cal system for when you're prescribing a psychotropic medication. If you're within the Medi-Cal system, you have to go through the TAR process. If you are a foster youth, you go through the TAR process and the JV 220 process, which you're referencing. This bill doesn't propose to change any of that. The judge will still receive the JV 220 based off of the information which we mentioned is now sort of undergoing a revamp and an expansion, and that'll be out July 1, 2016. They then have the opportunity to reject, deny, or request additional information on that JV 220. As Stu mentioned, and this is just sort of a conceptual issue that we're still trying to work through, is that the enforcement action by the medical board is sort of retroactive looking. We have, as we mentioned, the TAR process, the JV 220 process in place. That's all up front. And so I think where we eventually want to get to with this is let's look at the upfront prescribing practices, potentially even before a child and adolescent psychiatrist or any other prescribing physician is going through the JV 220 or the TAR process. Hey, I need a little bit of help. We are taking in a lot of Medi-Cal youth. I have some questions. We think that there is some space for that, for some sort of expert consultation. I believe the committee analysis references some other approaches that I think we'd be interested in taking a look at. I will say that Senator McGuire has worked and had conversations with us. He mentioned providing bill language to that effect. We're still trying to wrap our heads around sort of what the best approach would be. I think we definitely want to move forward with something that we know they will be okay with, but I want you all to know, and Senator McGuire to know, that we are committed to providing that as well.
I think the one item, Mr. Chair, is that a child can be in the foster care system from the time they are 6 months old to by the time they're 18. And then they can go from county to county, and that's another challenge that we currently have within the foster youth system. And those medical records aren't sent with them, or they're not requested by the next county. So what we need to be able to do is through the medical board at that snapshot of time, so maybe when the child is 10 years old, if they do find a pattern of overprescription, that could then be sent for proper evaluation via the medical board, and only in the most extreme cases then sent on to the Attorney General. I want to go back to the system that we currently have right now. We have two systems. A system that works for youth that have advocates, such as parents and relatives, and over 8,000 complaints regarding psychotropic medication was brought forward 2014 and 2015. Zero were advanced for foster youth. And by the way, they are our collective responsibility.
Every judge.
And well, it's actually us. So we're the number of states that has similar measures like we're asking for today has been able to show success. In fact, the number of states has seen, on average, 25% decline in the use of psychotropic medication when they have advanced similar measures to what we are asking for here today. Now, is this the only answer? No, we need to be able to invest in trauma therapy because these kids have seen ungodly experiences in their lives. But this is about data. And it is ridiculous to think that we're only going to do this for a year and then we're going to go, we're done. This is about a lifetime. And we know what the outcomes are for those foster youth. And that is why we asked today to be able to provide the data necessary to the medical board to be able to do investigations on only the most extreme cases in that snapshot of time. And by the way, these cases, and Stu's absolutely right, it could take a year or two, but rightfully so. We should not rush it. And the vast majority of those investigations that start at the medical board don't end up at the Attorney General's office. Only the most extreme cases. And what's good for those kids who have the resources should be good for our foster youth as well. And we're just asking for equity.
Very good, thank you. Other questions or comments? We have a motion from Senator Hernandez to, this would be to do pass to Senate Appropriations Committee. Please call the roll.